Hello, ladies and gentlemen. I am Carlos Emmanuel Delgadillo Flores, and we're going to talk about what are the legal sciences, the classification of the legal sciences, and how are they composed. First, we need to talk about what are the legal sciences, and all the sciences that have a complement or integration to the study of the law, because the law is a science itself, but it needs to be complemented and integrated by other sciences, and it depends also in the subject, in the public and private laws. But we're going to talk about the classification of the most accepted sciences that are to integrate the law and to complement the law, so we can understand how is the law integrated and complemented by the other sciences. There are three classifications, and we're going to see the classifications. The first one are the fundamental disciplines, that are the fundamental sciences. These sciences are vital to understand the law. Without these sciences, we cannot understand the law. Why? Because this integrates the law. There's a difference between the complementary sciences and the integration. The integration are the ones that are in the nature itself of the law. Okay? Without these sciences, we cannot understand the law, and we're going to explain that. First, we have the legal philosophy. The legal philosophy study not the values, does not study the values, they study how are the rules implemented, not the processes, and how the state is applying those laws in the community that they are moving. So the legal philosophy study the general principles of the law, but apply it in the positive law, in which is the law that is coercible and imposed by the state. Also, we're going to explain first what is the jurisprudence itself, and later the technical jurisprudence. The jurisprudence are the resolutions and sentences of the courts. It can be higher or lower courts of a country in the same way. In Mexico, we have 5 resolutions to create a new jurisprudence, but in the cases of the administrative and tax laws are only 3. Also, it's very different the jurisprudence in the neo-Romanist system than in the common law, that is the case law, statutory law, the precedent, like in the United States and in Great Britain. But there are differences between them, because the Great Britain has a parliament and United States has a Congress. It's very different because the Congress of the United States has the statutory law by the Senate and the House of Representatives, but the situation is that they are elected by the people. In Great Britain, they don't have that system. The House of Commons is integrated by the people, but the House of the Lords is not elected by the people. It's very different, okay? So, in the case of Mexico, that is the jurisprudence. The resolutions that are dictated in the same way. But the technical jurisprudence is the story of what the judge was thinking and applying to create that new jurisprudence. The jurisprudence is the law, okay? And the technical jurisprudence is why is the law applied in this way, how it was created and originated. That's the difference between the technical jurisprudence and the jurisprudence itself. After that, we have the general philosophy. That is the story of the values and how the relationship within them has the unique form to be applied in the law, because the general principles of the law is a formal source in a supplementary way in Mexico. Why? In a supplementary way, because in Mexico the codified law is the one that has more power. After that is the jurisprudence, the doctrine, the uses and habits, and later we have the general principles of the law, so we can have a better legal system in a mixed way, but we have a neo-Romanist system. The situation is that the general philosophy studies the situation of the values and its relationship and how it can be applied in different manners, not only in the law. That's the difference between the legal philosophy and the general philosophy. This studies the rules and how it's applied by the state, and these studies how it's integrated and complemented in all the sciences. Doesn't matter which one we're talking about. And it studies the existence itself of the human being. But that is another story. We're going to talk about the legal science. The legal science are the procedures that Mexico is applying in the laws. In this case, the legal science is the study of how are the procedures of the law applying, because in the penal code of Mexico we have the sanctions, but we have also the procedures, the national code of the procedures of the penalties in the criminal law in Mexico. The situation is that the situation of the legal science is how is the law applied in the procedure, and the legal philosophy is how is applied in the law itself, in the rule. Rule, procedure. Very good. This is how the law is applied, and this is what is going to be applied on. This is what is going to be done, and this is how is to be done, the legal science. Okay? Very good. We're going to pass to the next type of sciences that are in the law. These ones are the auxiliary disciplines, that these are a complement to the law. We can understand the law without these sciences, but this can complement the law, because law is this in the integration of the fundamental sciences, and with the complementary and auxiliary disciplines we can have a better view of the application of the law, because it's very helpful. The sociology is the origin of the law. Why? Because the law has its origin in the interaction of the people. We didn't have a penal code if someone didn't do a crime. We wouldn't have the penal code if someone didn't do a crime in their time. That's the situation in the sociology, the story of the people and how it's integrated. Also, we have the comparison of the laws. The comparison of the laws are the stories of the legal systems that can be analog, not analog, and how can be applied and have very nice differences and similitudes. As an example, we have the common law applied in Canada and in Great Britain. Great Britain, not England, sorry. England has two cameras in the legislative branch. They have the House of Commons and the House of the Lords. In the case of Canada, they don't have the House of the Lords, they have a Senate. That's the difference of the origin of the statutory law. Also, we're going to talk about that in the United States, the application of the common law is very different from Canada, because they have a Congress and not a parliament. That is very different. That is the origin of the common law system in the statutory law, not in the case law or in the judgment law. Okay? And also we can study the differences between France and Germany, the BFG and the Napoleonic Code. Why? Because its codes are in the same source, the Romanist code, but they have differences in their application. The German Civil Code, the BJP, has 5 books, but the Napoleonic Code only has 3. Why? Because they have an integration that is very different, but they have the same principles in some of the matters. It depends. That is the situation of the comparison of the laws. After that, we have the history of laws. How are the precedents upcoming to the laws that we have today? How are the processes taking advantage, so we can have a chronology of the laws and understand the legal system that is applied today in all the countries. Okay? That are the auxiliary sciences. Okay? We're going to talk about later, in this time, what are the axiological sciences. The last classification. These are very simple because are the story of the values and their relationship with the law. But this integrates, not complements, integrates these two sciences, the auxiliary sciences and the fundamental sciences. So, in a summary, the fundamental sciences are the sciences in which we need to understand the law itself, because are in the nature itself of the law. Also, the auxiliary sciences are the ones that complement the law, but are very good to understand a very graphic of how is the law applied in different systems, such as in the common law in England and in Canada and in Australia. It's very different between them. Okay? And in India, that has a mixed system, but that is another story. Okay? And the axiological sciences, that are the story of the values and how they complement and integrate these two type of sciences that are very helpful to understand the law. God bless you. Thank you. Thanks to God for this day. Have a nice day.